Hi, this is Hyderally. I'm a plaintiff's lawyer with offices in New Jersey and New York, and we concentrate in employment law. I want to speak to you today about a case that came down recently. The case was Rios versus Meadowlands Hospital Medical Center. And in this case, Rios had a coworker whose name was Hyderally Bailey, still probably is, Hyderally Bailey. And Hyderally Bailey had some instances of sexual harassment while she worked for the Meadowlands Hospital Medical Center. She was terminated. She initiated a lawsuit under the law against discrimination, the New Jersey law against discrimination for sexual harassment. While she was doing this, the supervisors at the Meadowlands Health Center approached Emiliano Rios, Mr. Rios, and said, listen, we know that Hyderally was your supervisor, and we really need you to talk about what a bad employee she was. We also would like you to go file a restraining order because you need to play ball. You need to help us out. And play ball was the exact words the supervisors used with Mr. Rios. They also promised him, listen, you play ball, maybe you get a promotion out of this. Mr. Rios felt very uncomfortable about the situation and refused to play ball. What ensued next was the hospital ended up terminating him. Now, lawsuit ensues. Mr. Rios contends this is a violation of the New Jersey law against discrimination, which protects people who fall within the protections of the LAD. So the issue here was Mr. Rios didn't know the details of Hydarally's sexual harassment complaint, wasn't involved in the complaint, she didn't share with him the details of the complaint. He didn't obviously share any details of the complaint with others at the Meadowlands. So he really wasn't involved with the complaint of sexual harassment, but he did know there was something going on that was inappropriate in what the hospital wanted him to do, and he refused, he objected to do it. The question is, does that bring you within the protections of this very powerful statute? And luckily for Mr. Rios, the appellate court last month in April of 2020, April 14th, I believe it was, of 2020, found in his favor. Found that although Mr. Rios wasn't actively involved in the complaint of sexual harassment, in fact, knew very little about it, he knew enough that there was some funny business, some inappropriate activity going on by the medical center in asking him to do the things they wanted him to do, such that it would violate the discrimination and harassment laws. And they found in his favor. A great vindication for plaintiffs pursuing claims of retaliation under the New Jersey law against discrimination. This is Hyderally. Be safe and be well.